Hi, everybody, and welcome to today's webinar. My name is Amy Forbes, and I'm the training manager at the Northwest Mental Health Technology Transfer Center, or otherwise known as MHTTC. Today's webinar is on behavioral health and tenants' rights with Andrea Kranzler, Elizabeth Powell, and Casey Burton from the Tenant Law Center at Catholic Community Services of Western Washington. And we first just want to tell you a little bit about the MHTTC network and what we offer. MHTTC is a nationwide network that is supported by the Substance Abuse and Mental Health Service Administration, or SAMHSA. Our network includes 10 regional centers and a network coordinating office. The MHTTC network supports resource development, training, and technical assistance and workforce development for the mental health field. And you can see by this pink circle at the top, our Northwest Mental Health, or Northwest MHTTC Region 10 covers Alaska, Idaho, Oregon, and Washington. And a little bit more about our goals, which are to accelerate the adoption and implementation of mental health evidence-based practices. We also heighten awareness, knowledge, and skills of the workforce, foster alliances, and address training needs among diverse partners, and ensure availability and delivery of free, publicly available training and technical assistance. You can also see on the sides of this slide that we do offer a lot of free resources, virtual learning communities, live webinars, self-paced courses. We do have a podcast as well, and you can also sign up for our newsletter. Just a few housekeeping tips before we get started as well. We will be sending a link to the webinar recording, slides, as well as your certificate of attendance within a couple of weeks. And then you'll notice at either the top or the bottom of your screen, however you have it, there is a chat box. We would really appreciate if people would use the chat feature for comments, greetings, observations. If you're having some technical issues and would like assistance from our MHTT staff, that is where that will go. Please reserve the Q&A box for questions that you might have for any of our presenters. They will be answering as many questions as possible at the end of the webinar. And also, we do have an evaluation at the end of the webinar. Please do fill it out. It really helps us coordinate future events, trainings. We really do read them and listen to what everybody has to say. We are required by SAMHSA to conduct this survey, and of course, they do not have an official position on the content of the survey, but we really appreciate everyone filling it out. And we do have upcoming webinars. This information is also available in the chat. And with that, I would like to welcome everybody. Welcome our presenters, Andrea Kranzler, Elizabeth Powell, and Casey Burton. Thank you so much for being here. And I will let the three of you take it away and introduce yourselves.
Sorry, I just want to interrupt and thank you so much, Amy.
Thank you. Sorry.
No. But I just wanted to say many of us have worked in housing or trying to secure housing for folks who are living with and suffering from a lot of behavioral health conditions, as well as many other oppressive things going on from society. And I'm very, very grateful. We did just do a very short podcast recording with the four of us, but I'm really, really grateful that you all are doing this today, that you've dedicated your law careers to this kind of advocacy, and that you're here to share with everyone on the webinar, as well as those that might watch it later, how we can better help folks that are not always given the best information, maybe fair treatment, don't have the resources to, push all of these things that maybe aren't fair. So really, really, I'm so glad that we were able to bring you here to do this topic. So just thank you from me, and thank you, Amy, and we'll let you all take it from here. Thank you so much.
I think we'll start with an introduction from our fearless leader, Andra Kranzler, and then you'll hear from Elizabeth and then myself.
Hi, thank you so much. My name is Andra Kranzler. I'm the directing attorney here at the Tenant Law Center, and the Tenant Law Center provides important eviction defense for renters across Martin Luther King Jr. County, where Seattle, Bellevue, cities, Kent, if you're familiar with the Pacific Northwest, we're 39 cities in Martin Luther King Jr. County, and then we work in collaboration with partners across the state to help support renters and their rights to stay housed. And we do that through policy advocacy support, outreach support with tenants, organizers, and other civil legal aid partners. I came to this work as a former housing landlord and family advocate for people living homeless. I worked in a program that helped families exit out of shelter into transitional housing, and we provided 2 years of substantive case management services. And it was very low barrier, so you just couldn't actively could not have been actively being pursued by your abuser because we didn't have that type of safe housing to prevent someone from maybe accessing the unit. In that, people took me to the most difficult things that they were experiencing, because I would say, what's the hardest thing you have to do? And what I learned in that process is that reasonable accommodations help people stay housed, how people stay employed. I would go on to law school to be a case manager for people living homeless, or at least that's what I thought. That's not actually what happened right away. I ended up going down an employment lawyer pathway in the last 2 years, have been able to bring my experiences to the Tenant Law Center. And our advocates here, Casey and Elizabeth, can attest to how we support our clients and just everyday renters, and how we work really in concert with case managers and social service providers. And we prioritize people who need reasonable accommodations in our case acceptance process. So we're really excited to be here today and to educate you, as you are our first line of defense. You are issue spotters, and you can kind of help people navigate the trenches that are impacting their lives. So thank you so much again for having us. Pass the baton to Elizabeth.
Okay, I've unmuted myself. Hi, I'm Elizabeth Powell. I'm an attorney. I'm licensed in Washington. I am not licensed in other states. So what I'm going to be talking to you about today is going to be necessarily limited by what I'm allowed to talk about. I have been doing housing related law for the better part of 20 years. I've been involved in some interesting appellate work. I have been involved in the trenches level at the commissioner's courts, trying to make sure that people get due process and the ability to stay housed. I've found that housing is always kind of a secondary but terminal crisis for people. Typically, something else has happened. And then as a result of that other thing that happened, now there's a housing crisis. And as literally nothing in this world is improved by somebody being made homeless, we're trying really hard to do what we can to avoid that. We can divert these cases before they ever wind up in court. Sometimes we can resolve them by mediation. Sometimes we can resolve them with agreement. Sometimes we cannot. But we can almost always make sure that the people who are going through this are not in complete panic mode, thinking that the sheriff's going to show up at midnight. So I think there's a benefit to that. And that's why I'm really grateful I get to do this work.
Hello, my name is Casey Burton. I am a senior staff attorney at the Tenant Law Center. We've got two, so I'm A, not the. And, housing work has just been a passion of mine for the past several years. And I think that there's unfortunately a lot folks don't know, and we're hoping to change that today. So what I'm going to do is I'm going to start sharing my screen. We've got our presentation ready to go. And then I'm going to change this so that I can see. Perfect. So clearly we're going to be talking about behavioral health and tenants' rights today. And the way that, okay. Oh, working. Oh, here we go. Okay. Thought I messed up something. So what we're going to do is we're first going to jump into the federal law. That's obviously broader and going to accommodate some of the folks that I've seen post that they are from outside Washington state, but it's something that's still applicable to you. And then we are going to delve into state level law and how that impacts folks. Then we're going to talk a little bit about some of the things that you'll probably see pretty frequently. So reasonable accommodations, reasonable modifications, support animals, service animals, and we are going to make sure to get you some resources at the end of this. So first things first, the relevant federal laws in this instance are the ones listed. We've got the ADA, FHA, and Section 504 of the Rehabilitation Act. Now, what do each of these mean? So first things, Americans with Disabilities Act, also referred to as the ADA, and it does prohibit discrimination against people in a variety of areas, and definitely relevantly here would be public accommodations, government programs and services, and that can be a useful tool that you have in your pocket. We also have the Fair Housing Act, and so this prohibits discrimination basically in relation to housing. And it's pretty comprehensive, but you'll see that the federal laws actually have some overlap. However, that's kind of helpful, and we'll get into that in just a little bit. But basically, any federal program, if you're, running a federal housing program, the Fair Housing Act is going to apply to you. So that includes housing authorities as well. And then Section 504 of the Rehabilitation Act. And so this is just general prohibition on discrimination based on a disability. And this applies to anybody getting federal money. So if you got a federal grant, this applies to you. If you got a federal contract, this applies to you. And that's something that's really important to know. So like I said, there is some overlap, but that's good because there are some exemptions. So under the Federal Housing Act, it doesn't apply to owner-occupied dwellings with no more than 4 units, single-family homes sold or rented by the owner, and so on. And that can obviously be frustrating, especially because if you have a tenant who's renting a room in someone's house, that can make your life a little bit difficult. But again, we have some overlap and we're going to go through that. Next, we've got the ADA, and that basically is exempt. Religious organizations and private clubs are basically the ones who are exempted from that. And then Section 504, anybody not receiving federal money. So it's pretty straightforward. But of course, if you have questions, we'll be happy to answer those at the end. And now, more specifically at the Washington level, we've got the Washington Law Against Discrimination. And as you can see, that's much broader. And the relevant portion here is it bans discrimination in a number of fields, but for our purposes, we are going to talk about how it bans discrimination in the context of real property transactions. Now, you might think a real property transaction is just like the sale of a house or something like that, but leasing is a real property transaction. You are giving someone possession of real property for a set period of time in exchange for money, covering utilities and so on, following rules. So it does actually cover leases. And of course, this has exemptions as well. And that also is religious or sectarian organizations, not for profit. And that can be a bit limiting, but we still have a lot of options. And there are, of course, always regulations at the local level, well, frequently at the local level. So you might have to talk to a housing attorney in your area about what could apply to your situation if you are not in Washington, but we can tell you all about Washington. So we're going to go into who's protected. As you can see, federally and state-wise, state's a lot more comprehensive, but the federal level has actually a lot of power because so many people rely on federal funding to do anything related to housing. Maybe you've got a loan that's somehow related to the government, that is how you own your apartment complex, or maybe well, I'll let Elizabeth get into it actually, because she's going to be our expert on this. So handing over to Elizabeth Powell.
Okay, I will try and pipe up and make it be more clear. The thing that is frustrating for a lot of people is that the Revised Code of Washington is divided into titles, and Title 59 is landlord-tenant. Title 59, Chapter 18 is residential tenancies. There is nothing in 5918 anywhere that talks about fair housing or protection. That is contained in Title 49, which is cleverly labeled labor. So, of course, you would think to look there when you were looking for fair housing protections. It's at Title 4960. And so, but Title 4960 is absolutely clear that it applies to any sort of a real property transaction, including the application for a real property transaction. So at any point, it is possible for somebody like a HUD investigator to go see what sort of responses people are doing. They send testers, and that is people to go see if African couple is going to get a different statement from somebody than somebody who says they're a veteran, whatever. This is how they test it. So in Washington State, there are a number of specific things that are considered protected status. And actually, the city of Seattle goes even further, and they protect against even more things. And to the extent that these are all things that somebody has called out and said, this is really important to us, then let's protect it. So anyway, the most interesting thing that our state has done recently is to get rid of source of income discrimination. And what I mean by that is that if you go to a landlord and you say, hello, I have money, I want to rent here, and the landlord says, great, where do you get your money from? And you say, well, I have a voucher. That landlord can no longer say, I will not take your voucher. They don't get to do that. And that levels a important field for a lot of people. So I'm absolutely think that it's an important thing that you can work with when you've got a client who may be coming up with alternative sources of income. There is a state and some local restrictions on landlords when they are living in a unit and renting out a room within that house to somebody else. And there's slightly different restrictions on that. So a person who owns a house and rents out 2 bedrooms and shares the kitchen and the bathroom doesn't have the same duty of care to a tenant under some circumstances. So that's the only appreciable difference here. Okay, so I put together this slide on the theory that sometimes you want to know who to go talk to. And we have essentially 3 levels of agencies here. The Fair Housing Center of Washington is available as a conduit, a way to get to HUD if you feel like somebody's federal rights are being dismissed. This is one way to approach them. And it's not, well, my client feels like they're being discriminated against. This is the thing that happened, and perhaps there's documentation about it. Perhaps there are witnesses or something. They'll investigate. On the state level, we have the Washington Human Rights Commission, and theoretically, they investigate the same sort of thing. I find myself wanting to refer people to fair housing because I personally think they do a better job. Anyway, and then the local, in King County, there's an office of, or in Seattle, I'm sorry, there is an office of civil rights, but you can also go talk to, again, the Human Rights Commission or the Fair Housing Center. Different cities within King County don't necessarily have their own office of civil rights or something equivalent. The city of Tacoma does, and they call it the Office of Human Rights and Equity. And so those are other places that Washington residents can take an issue and complain about whatever it is that they're experiencing. So those are just 3 different levels, and you can approach it probably more efficient to start at the most local and then go up as necessary. So, and then this is the big thing that comes up in this is the difference between what is an accommodation and what's a modification. And this is where Andra's going to take over.
Thank you. I just wanted to put in the chat also the Department of Justice Civil Rights Unit. There's a 206 phone number there, but we can get you a 1-800 number. But Department of Justice can take complaints for reasonable accommodations or modifications that are denied. And so I just want to kind of go over again, disability is one of the protected classes that are covered under the federal and most state and probably some local jurisdictions. And wherever you're at, you should look to see if your local jurisdiction has adopted any additional protections or set up any administrative agencies to help people navigate this system. In general, an individual with disability is someone with a physical or mental impairment that substantially limits one or more major life activities. Those can be hearing, speaking, walking. A disability can also affect a major bodily function. So your immune system, organs, neurological activity. It can also be something that is a condition, like an orthopedic or visual condition, including human immunodeficiency virus, intellectual development disabilities, illegal use of controlled substances, and alcoholism. And that term major, it's not a high standard that a person has to meet to be able to be identified as a person with a disability. The federal disability laws protect any individual who has a record of having any impairment or who is regarded as having an impairment. So that is a good thing for everyone here because just generally, if our federal rights cover all of us, right? And then our state and local laws are based on whatever state we live in and what the electeds and constituents have tried to enact. So City of Seattle is a good example of how renters and people have organized to try to enhance renter protections. And so we just want to just make sure that when you are thinking about or you're talking to a client and they're saying, I have a disability, thinking about, and they're saying, my disability, because of my disability, I either need an accommodation from my landlord or I need a modification to the unit. The unit can also and sometimes include the physical space that is community space outside of the actual rental unit. And so we have mentioned that there's 3 different laws that govern your rights if you have a disability. And so that they also have 3 different definitions for reasonable accommodation and modification. Here on the slide, you'll be able to see the definition for modification and accommodation, but I want to just explain a little bit how the Fair Housing Act says a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service. And the Fair Housing Act makes it unlawful to refuse to make a reasonable accommodation. Section 504 says that under 504, the requirement to make a reasonable accommodation applies to any changes that may be necessary to provide equal opportunity to participate in any federally assisted program or activity. And that also includes a change, adaptation, or modification to a policy, program, service, facility that is necessary to allow a qualified person with a disability to fully participate in the program. Reasonable accommodations may include changes which may be necessary in order for a person with a disability, again, to use and enjoy the dwelling. And if it's covered under 504, Section 504, then that is when it does include the public and common spaces. If you are under Section 504, then that reasonable accommodation must be provided and paid for by the housing provider, unless the providing them would be like an undue financial administrative burden. But that doesn't mean that they still don't have to work with the person. So they still have to engage in an interactive process to come up with an otherwise reasonable accommodation that would not cause the same maybe undue financial hardship or burden. And then lastly, the ADA, Title II and Title III of the American Disabilities Act, public entities and public accommodations are the same. So they use the term reasonable accommodations or modifications to speak to also their accommodations. Does that make sense? Because I just want to clarify that we are providing you two definitions of general terms, but they're a little bit blurry based on, or blurred a little bit based on which act you are under. I think we can move to the next slide.
All right, Elizabeth, you're back up.
I am. Thank you. Okay, so the most important thing in communications between tenants and their landlords is that they not happen informally. And in this state, that means you put it in writing. And it doesn't have to be, a formal business letter, but it has to be on paper. It has to clearly identify who it's coming from. It can say, "Dear landlord, I need you to allow me to do blah, blah, blah. Thank you for your attention to this matter," and it's signed. And so it's okay if it's in handwriting, as long as it's legible. And it's critically important to have a copy of it and to know what date it went to the landlord. And if there's something some buildings don't have an office, so you have to actually write to somebody to send them a notice. But that's really important, at least on Washington law, and that we don't try and do that on website portals. And I got the question coming up, can I do that by email? Okay, our law, the Residential Landlord-Tenant Act, was written in 1972. And in 1972, we didn't even have fax machines. And so when a judge looks at something and says, well, this says it needs to be in writing, the judge is literally looking for a piece of paper. Your, jurisdiction may do it differently, but my gut instinct is that if there's any question, a judge is always going to be more open to the idea of a exhibit that's a piece of paper that says, this is what I wrote, this is what I said. So one accommodation that gets a little turnaround sometimes, people who receive Social Security disability income get a check that might not show up at the same time as the rent is due. It is a reasonable accommodation to ask to have the rent due date changed so that they're not incurring a late fee every single month. And so that's a request. Dear landlord, I get my payment from whoever on the 10th of the month. I want my rent to be due on the 10th and not late until the 15th. That's perfectly reasonable. And so anyway, the other thing that I see people being concerned about is whether or not a medical provider needs to violate HIPAA and tell the housing provider everything about the tenant's disability. No. You can just say, I'm qualified. This person needs an accommodation. Good enough. Stop right there. You don't have to, go a lot further than that. Okay. So, anyway, and then, behavioral issues, one of the ones that I've seen, especially in the last couple of years, is people who have trouble with hoarding, and that their landlords are concerned that the buildings are going to get into disrepair, and that the tenants are not safe, and the tenants are terrified they're going to lose their belongings. And how do you fix that? And I think as a behavioral therapist adjacent person, that my suggestion would be to make sure that these people are having contact with other people in the real world, and they can make sure that they're checking in and that things are going okay for them, so it doesn't turn into a horrible problem for everyone. Anyway, the other thing that Washington does, and this was even before Washington instituted right to counsel, was the idea that the court can offer persons who need assistance with accessing the court reasonable accommodation in the form of a lawyer. And there are people that need that. And I've represented them, and I'm really happy and glad that I can, because I have just a little bit more time and the ability to dive into the problem, figure out what the problem is, and then present it. And that they are much likelier to actually get access to justice if they have that accommodation. So I can't say as far as other states, but it's a big deal here. And then during the pandemic, our state put together the right to counsel program so that persons who were at risk of losing their housing, and I don't remember what the income qualification was exactly, but it was pretty generous. It was like twice the federal poverty level or something, that those people could be assigned counsel. And then there was a huge training program put in place to make sure that the attorneys knew what was available to defend people who were facing eviction. And anyway, it's worked out, I think, better for a lot of people. It's not perfect, but that's what we mean by reasonable accommodations. The other one that works in this state is, and I'm not sure who's discussing this, but I know it's coming up, is the difference between what we call a service animal and what we call a emotional support animal. So under the ADA, a service animal can be a dog. And there's a definition that's been individually trained to do work or perform a task for the benefit of a person with a disability. And that's kind of the end of the story. Service animals do amazing things. There are service animals for people who are deaf. There are service animals for people who have seizures, animals that are trained to like dial 911 and bark until somebody shows up. It is the coolest thing in the world. Washington State also recognizes miniature horses as service animals. And before you laugh, here is why. Dogs don't live as long as miniature horses. A miniature horse can live 25, 30 years easily. And a dog, if you're really, really lucky, might go 12, maybe 15 years. That's why Washington allows miniature horses. So those are service animals, and those are distinguished from emotional support animals. And so an emotional support animal requires that there be some kind of medical treatment plan in place so that this person can be able to enjoy their housing opportunity. And it can be a little vague. It can be companionship, loneliness, help with depression, anxiety. They're not specially trained, but they assist persons who have that kind of disability. The difference is if a person comes to a housing provider and says, I have an emotional support animal, the landlord may inquire as to whether or not the emotional support animal has a medical basis, in which case the tenant should be able to come up with a letter that says, I am treating this person. This person needs to have this emotional support animal. That animal is not a pet. It does not pay pet rent. It does not get to be excluded if the building says, no, we don't take pets. And obviously, this creates a lot of friction for people. And all I can say is that, at least in our state, the first paramount duty is that people who are subject to the Residential Landlord-Tenant Act operate from a position of good faith. So if you've got a pet that you're attached to, but it's not an ESA, okay, it's a pet. If it is an ESA, all right, here's documentation. If it's a service animal, a housing provider can inquire what the animal has been trained to assist with. That's it. They do not get information about the person's disability or what it is that brought them to that point, nothing like that. So what they're trying to do there is to enable a housing consumer to be able to maintain their dignity and their independence as much as possible, while at the same time, requiring that people look after themselves, and that service animals are a very particular sort of animal that is the antithesis of a pet. So those are my thoughts about service animals. The days.
To jump back real quick, we did kind of skip over modifications really fast. It's
I'm
the same
sorry.
process to request basically, but you do have to pay. And that's the big difference between an accommodation and a modification. Like we noted before, it's a matter of policy versus physical space change. And if you change the physical space, you have to pay for it. But we do have some that's included in the resources at the end. We've got a link that y'all can look into.
And also in my experience with
right here.
requests is that a lot of times the modification request is actually inures to the benefit of the landlord, and they're not going to ask the tenant to pay for it. So for a senior having a lower mounted shower on the wall or a grab bar or something, that's an improvement for the landlord. So it doesn't necessarily mean that the landlord must require the tenant to pay for it. It's that the landlord can. So that's a difference.
Elizabeth, could you talk
Yeah.
a little bit about what people need to do to get somebody appointed to help a person with a disability under GR 33?
Every superior courthouse in Washington State will have a administrator who is in charge of GR 33 ADA accommodation. And so if I was reaching out to a court, that's where I'd start, is to go find the administrator and say, who in your office is doing this? And then a person who's trying to assist, it may take an in-person visit, it may take a Zoom call, it may take something, but the ADA coordinator is going to want to have enough information about the situation to make a decision as to whether or not this person needs accommodation. And they're going to bend over backwards to make sure that people who, they're not doctors, they're not qualifying them, they just want to make sure people get accommodated. At the same time, not overloading the system with people who don't need accommodation. So, is that what you're asking, Casey?
Sure was. Thank you.
Okay.
So these are obviously, the resources that we have. There's a medical provider guide that's also going to be sent out, and that kind of walks you through, if you're a medical provider, what do I need to put in this verification letter? And that can help you with it. There's also the Northwest Access Fund, and they can send you to places that will help you fund those modifications if the landlord won't cover it. And the Fair Housing Center, they're great. We refer a lot of folks over there, and they have, they know how to throw their weight around when the time is right.
And they know how to get organizations to pitch in. There's an entire subgroup of people who will put in wheelchair ramps. Sometimes that's just what you need.
So I just want to add a couple of things. I think you can file a HUD 903 complaint, and that can help people get the federal government engaged in the request for accommodation. I think that you can advocate for your, like, the perfect, but also having a conversation with the tenant about, like, if you don't get exactly what you want, what else will work. It's an interactive process. And so this idea that folks can are going to just get what they want immediately without pushback, maybe at a different time. But right now it's just not, it doesn't always feel like it's negotiable. So I think if you can prep your client and just having that negotiation, if you know where their triggers are, figuring out like what helps to kind of address those are really important things. Like being in tune with kind of like what your client has said can be really helpful, so that you don't unintentionally advocate outside of the space for the person, and that you can hold whatever that person has said are the most important things to them at the very top of your advocacy kind of list, because the accommodation or the modification will need to work for the person. The other thing that I've seen is that sometimes the financing of different modifications is an issue, and it's brought to bear. So that's just something that we try to use unrestricted funding for, to try to pay for things that so sometimes we'll be using a reasonable accommodation to address like a 10-day comply or vacate notice where somebody maybe has violated the rules of the lease agreement. And in a scenario, say the person had a violent outburst in their unit and the landlord was going to evict them, we might ask for a reasonable accommodation for this person to be able to go to anger or behavioral health or something, or to have a medication readjustment. And so if we're able to, get that accommodation, then the landlord would not be responsible for paying for the medical treatment, right? It would be on the person. And so then we might be looking to social services or resources to pay for that treatment. Just some tangential things that I think are out there. And then one other thing I just wanted to say is that language access is an accommodation. If you are a person who needs either an interpreter or translator, or you're hearing or visually impaired, those are accommodations that can also be granted. And I think Casey had some comments, so I'll pass.
Yeah. Well, you brought up something that I'm glad that you did. And that is if there is some sort of behavioral issue and they need to go into treatment for it. So that can obviously be kind of messy, but under the HUD DOJ joint statement, which I'll make sure that we add as an attachment. I think I sent it to you all, but I may not have. However, it basically says let's say you have a client who has a violent outburst and they threaten someone, you may still be able to get a reasonable accommodation if they get the treatment that Andra is talking about, because you need to show that this isn't going to happen again because they are now in treatment. And we're asking that you would provide the accommodation, that you rescind the notice because this person needs to get treatment. They're getting the treatment now. The problem is resolved. And so please let them stay. And they might push back on that. And if a landlord outright says no and just refuses to play ball, that's definitely a time when you could get us involved if you are in King County, because like Andra said, it's supposed to be an interactive process. It's not supposed to be, can we please have this? No, and don't talk to me about it ever again. That's not allowed. So did you want to jump on your tangent, Andra, or do you want to go over to questions? Okay, then we'll head over to questions. So, oops, there we go. All right, so I see we've got a number. Okay, so can a landlord limit the number of emotional support animals a tenant can have? Maybe. Actually, Elizabeth, this is definitely.
Oh, I was answering too.
Oh, sorry.
I've been answering them in the chat. So if you go to answer,
oh, okay, I didn't know that
because I've got the answering them as they've gone. So you can go through and read them and add to what I've said.
Well, just to make sure that we are letting everybody know, for the folks that maybe are on their phone and don't have access to the chat, the answer is maybe. And the problem with lawyers is we always say it depends, but it does. So Elizabeth, would you like to speak to this? Maybe.
I will say what I answered, and then maybe Elizabeth, you can add. So I said they may need to show that they need that their need for additional ESAs is connected to the disability, and I provided the HUD guidance. And so I think you would need to show some type of nexus to the disability and the additional emotional support animal.
Yep,
that's
but
it.
Now, if you had an emotional support animal, and you had an emotional support animal, and you also had a service dog, that could be also, you could speak to maybe the difference between the types of, like one is for emotion and one is for service, and that might be a way to advocate for additional support.
The other tough category is service animals in training, because there really isn't a lot of protection for that. So the idea that you have one animal that is a service animal and another animal who is in training to be a service animal, and the one in training can be an emotional support animal, that would make sense, as long as, you know, it isn't just completely being made up. So an itty bitty dog is not going to provide guide dog services safely and reasonably. So you wouldn't have your German Shepherd for seeing eye dog, and then your Westie being the emotional support. But oh wait, the Westie is actually in training to be a service dog. How is a Westie going to be able to do that? And maybe it can be done. And there are organizations out there that work on this stuff. One of my favorites is called the Delta Society, which sounds kind of terrifying and Illuminati-esque, but they're actually a really good group that deals with service dogs. So that might
Sorry.
take a look at. Sorry.
No, you're good. I just want to make sure you had the chance to finish.
Right.
So then the next I see, did you state that property managers can't require tenants to pay rent for ESA animals? That is correct. Is it a service animal or support animal that is part of medical treatment? They cannot charge rent for it. They cannot charge a pet deposit for it. That's not allowed. If that's happening, no. Are adult family homes also regulated by Fair Housing Act or ADA? It depends on how they're funded and sort of how they're structured. Is this a thing where they're paying rent, or is, because the way that the RLT, sorry, we call the Residential Landlord-Tenant Act the RLTA because it's a mouthful. So the way the RLTA works is you might be exempted from the protections they're under if you living there is sort of incidental to the services being provided. But that doesn't necessarily mean that like the Washington law against discrimination wouldn't apply. The ADA could potentially apply. It depends. It's a lawyer, so I'm sorry.
And we're talking about Washington.
Well, and
I are.
I think also some of this is federal. So I added an answer. I added that I also think that like that depends on the funding source, as Casey said, but it's like if the adult home is more than 4 units and not owner occupied, for example, then it might have the 504 protections if it's serving low income people. But even if it were serving low income people and it did have those it was three or fewer units and it was owner occupied, then they may have exemptions. So it can be really tricky to try to figure that out. Sometimes it's stated in the lease agreement, but sometimes you do have to do some investigating, and that is the good time to give a referral to a third-party agency. Every agency has some type of a human rights commission, or every state has some type of a human rights commission, or the Equal Employment Office commission can refer to a local entity. Attorney general offices are really good resources for state to get just kind of some additional enforcement, maybe on some civil rights. They can sometimes be a good resource. Department of Justice and Housing and Urban Development are always good resources. I say as a case manager, there's always one person. Take the risk and make the phone call with the person and say, help the person tell their story and file that phone complaint. And those can be really empowering tools for people. And you can learn a lot about how your state enforces its fair housing laws and who those folks are. And then hopefully there'll be opportunity to deepen collaboration.
The next question I see is, if a request is apparent, it's my understanding does not need to be in writing, what are the best ways to address not accommodating a request like a wheelchair ramp verbally? So you're right. Technically, it doesn't have to be in writing, but writing is always best. I kind of say if it's not in writing, it doesn't count, but that's because you then don't have any evidence that happened. So either keep a log of the requests or do the request in writing. If they're refusing, then that's a problem. I'm not sure where you are. If you are in Washington, then I would definitely recommend reaching out to Fair Housing or the AGO because that's a problem. Can you educate on the disability related to addictions? I've been talking a lot. I'll defer to the others. It's tough.
Yeah,
is the
so
answer.
I think if you have a addiction or suffer from alcoholism, and those are impacting your ability to fully use and enjoy your unit, and you need services, then those are protected. And you can, it is a protection in terms of making sure that you can say you need an accommodation. So for example, if you had a client who had a chemical dependency issue and they had been doing well, they hadn't had any, any life impact that was, the addiction was causing problem, and then all of a sudden things start happening, and now the person is causing disruption in common areas, in quiet hours of the building, right? That person could make a reasonable accommodation that maybe they would go into treatment, or maybe they would join a harm reduction program, that they could have some type of a measurable way to show I'm doing this thing, I'm investing in here, I want to stay housed. I saw that a lot when I managed the apartment complex that was permanent supportive housing. Every person was connected to Sound Mental Health or community psychiatric clinic or some larger mental behavioral health provider. And what would happen is that folks would be doing really well. And then they would slowly stop taking their medication, and maybe they would start to use other, non-medical substances. And then I'd have issues. And so what I would be able to do is get a reasonable accommodation to work with the case manager to help the tenant, comply with the 10-day pay or vacate unit. So that's how that kind of works out in practice. I'll let Casey speak because I think she had something.
I think Elizabeth started to say something.
Oh, sorry.
And you're just bringing up a really important point. In Washington State, we have two different categories of housing. It gets called reentry, or it gets called clean and sober housing. And it basically means the same thing. It's halfway housing. It is somebody coming out of custody, whether they've been at one of the, federal or local or state institutions, or if they're coming out of a rehab program. Sometimes that's related to some kind of criminal justice issue. And so what those clean and sober houses do is they provide a really low cost rental option for people. And sometimes it can be a little bit like warehousing. You could have 15 people in a 3-bedroom house, and each one of them is paying $200 a month, and they have a rent. The problem comes when the clean and sober landlord thinks that all they have to do is wave their hand and say, "Be gone," and the tenant has to pack up and leave. And that's not true. Clean and sober housing in Washington is governed under the same Residential Landlord-Tenant Act. And there is a modified notice statutory plan where a landlord can say something like, "I am requiring that you go get tested for drug or alcohol right now." They can do that. And then they can demand that the tenant return with a test in some reasonable amount of hours. But that doesn't allow them to then pitch the person's stuff outside and change the locks. And a lot of these clean and sober people think that's what they get to do. It is not. So rather than lose that critical resource, it is better to make sure that those housing providers understand that they are subject to all the same rules. And if they want to have somebody not be there any longer, then they have to give the same due process consideration, notice, opportunity to respond, opportunity to be heard by the court. And so that can sometimes be an adventure.
Awesome, thank you. So we are trying to get through some of the questions in the question answer. I don't know that we're going to be able to get to all of them. So as far as resources in your area, like what we shared, I would say start by going to a local fair housing organization. Just Google fair housing, whatever county you live in, and that will probably get you started. And if they don't have information, then they can at least send you in the right direction, because that's actually how we found our resources. We were emailing with the Fair Housing Center, and they're like, why don't you go talk to these people? And then voila. Could you direct me to the federal law that states the landlord can't charge extra for ESAs and service animals? Elizabeth, do you want to drop that CFR? Because you're better at memorizing numbers.
I don't know that one off the top of my head.
Oh, okay.
I'm sorry. Yeah, I don't have my notes in front of me. But
it is generally, I would say, look at the materials that are related to that. So if you're on like WashingtonLawHelp.org, they've got stuff about reasonable accommodations as well, and I'm sure they have the citation in that. It's hard to memorize the numbers of all the laws. As a mental health provider, I'm curious about the timeline for asking for reasonable accommodation if there are concerning behaviors. Seems like if a tenant has been asked to leave, that is worst case scenario, because that seems like a crisis to figure out a letter or accommodation immediately. Wanting to know what advocacy I should be aware of, or for perhaps more preventative measure. There's not like a specific time, at least that I'm aware of. It's just better to get it done sooner rather than later, because if you wait till the 11th hour, like maybe they're already in eviction court and now you're asking for a reasonable accommodation, and it's just really messy. So yeah, I would say the sooner the better. Do either of you have any recommendations, Elizabeth, Andra?
Well, I'm going to jump in here. You talk about the person asking the question, a tenant being asked to leave. I would want to know the nature of that ask. Is there an actual notice that says you have done something horrible, you have to be out of here in 3 days? And if so, that is very much a reason to, for example, give us a call and say, can they do this? And there are circumstances under which they could, but being asked to leave by a landlord does not mean a judge is going to agree with them, and a sheriff isn't going to do bupkis until a judge tells them to do something. So it is sometimes important to get everybody to calm down a little bit, stand down, and decide what's the best course of action for the tenant. And sometimes that means that the tenant's going to be better off someplace else. It's true, but generally not, because they're being told by their landlord that they better leave. So.
Oh, here's an interesting one. I have a landlord that is allergic to dogs, and that's why he doesn't want animals. He doesn't want to replace everything when he decides to move back into the unit when the time comes. So regardless of his health later down the road, does he still have to accept support animals? And that's, you don't have to apologize. That's perfectly fine that you were asked a clarifying question. Thank you. Elizabeth, you want to take that?
Yeah, I don't think the landlord's allergies are necessarily dispositive. I think that the landlord could certainly, well, if it's a service animal, they don't get to charge for cleaning. So perhaps that landlord wants to reevaluate what they want to be doing to earn money. Yeah. Because that's not accommodation. Even saying, I'm going to make you pay to clean this place. If it's a service animal, it shouldn't be developing some kind of, but you can't be responsible for other people's allergies. No. Right? Yeah.
Do these rights apply to someone who is housed by family and are not paying rent? Not really. It depends. But probably not.
We distinguish between tenancies and what we call tenancies at will, which is a big aphorous category that includes people who are living, on their mother's couch or with other relatives or whatever. And not to put too fine of a point on it, but either there is a landlord-tenant relationship or there is not. And so in the tenancy at will environment, arguably it's not a residential tenancy, but on the other hand, the person's rights to remain housed are also a lot more vague and aphorous. So it kind of cuts both ways.
What else do we have? There was a question about asking if the building would put in tempered glass into a unit as a modification. I think that is a tricky one because that's pretty major.
Yeah.
And I'm not sure, tempered glass. I mean, I don't know enough
That's
about
the
glass
expensive
surgery.
stuff, isn't it?
It's the kind they make like pint glasses out of because they're not supposed to break. Though I did accidentally break one time, microwaving an egg in it. It's a long story. But it's supposed to be more tough. I guess I'm guessing this is to prevent self-harm. Yeah, oof.
Yeah, that would be a tough one.
If you could cover the cost of it, but that's also going to be huge inconvenience. So if it's super unreasonable, they might say no, and they might be allowed to say no.
Yeah.
So I would consider what other alternatives there are, which is not a satisfying answer, I know, but what else do we have? Oops. Is there a responsibility by a housing case manager or agency to inform a landlord about allegations of emotional support animal potentially dangerous to other animals? I think that would depend on how you know it's potentially dangerous, if it's attacked other animals. I mean, because if it's a support animal, it shouldn't be acting that way. Elizabeth's got her hand up. Go for it.
Oh, my favorite case in Washington State is called Frobig versus Gordon. And I don't remember who was who, but one was a landlord and one was a tenant. The tenant kept a tiger. The tenant had
You've never told me this story.
come over to visit the tenant and the tiger, and you will never guess what happened. Yes, the visitor got hurt, and the visitor sued the landlord because the landlord, was in charge of the land. And Washington courts said, no, this is not the landlord's problem. And Washington has stuck with that version of premises liability not falling on the landlord when the tenant brought the problem to the property. And it really hasn't changed since then. So I would point out that, at least in Washington, that designating an animal as being dangerous is a very specific administrative process that requires whatever the local agency is, whether it's the ASPCA or the Humane Society or whoever, to actually do an administrative finding regarding the animal. And they can order an owner to isolate that animal and to make it so they can't go outside unless they're muzzled or whatever. But that's a very formal process. And to the extent that some other random person shows up at the landlord's and says, I'm scared of my neighbor's dog. Okay. But that's not a finding that animal's dangerous. And so I would want to see that formal process. And in my experience, people who have animals that are not well socialized usually know it. And so they're careful because they love their animals and they don't want their animals to get destroyed. And so it's kind of a trade-off in both directions. But I also agree to the extent that Casey is saying that a service animal has no time or truck for anybody else besides their person. That's it. That is the only thing they're focused on. And a well-trained ESA, same thing. They have no interest in barking or jumping or, dancing around or anything else, because that's not the way they behave. And yeah, Sandra.
Can I just add that, they might be misbehaved. It might be a cute little Pomeranian that is really great at being that emotional support animal when someone is about to go into seizures. Because if you don't know, Pomeranians can help calm seizures, and they're tiny dogs, right? But if you got a new one, they might be all over the place, and they might pee and poop all over the place. They might just get excited and just pee right there. And so you could be getting in trouble because the dog's peeing in the hallway. So, you could say I need this emergency support animal. You might have to pay, clean it up. I would say clean it up, get it out there, spray, do what you got to do to, not cause it to be an issue, but then have a conversation with your client about what are some concerns that you have about the dog and what are some ways you can mitigate those concerns? Because if the worst case scenario happened, that person could be liable. It could impact their housing. And so I think we've got to have these really difficult conversations with our clients and help them lean into conflict and then successfully come up with plans that can mitigate that. Right. So you have a dog likes to jump on people or do whatever. Well, are there some programs or some resources where you can take that dog to a dog training class or something like that, right? And if it did escalate, could that be something that you could pitch to the landlord as a way to try to, resolve the issue, where the person doesn't have to be vacated and or the dog doesn't have to be removed from the premise. But I will say that every issue that comes before the Tenant Law Center, there's valid points from the tenant. But the tenant has a duty and a responsibility. And unfortunately, our society just doesn't really give a lot of credence to folks who are needing, accommodations. And so, we're here trying to say, hey, everyone should get an accommodation. Everyone should have this right. And I think that in order for that to really happen, we also have to have really difficult conversations with clients sometime about how their actions are contributing to the issue and then how to pivot so they can stop the action from impacting the landlord, and then understanding, this is where the landlord violated the law. This is where the landlord is kind of correct. This is where we need to try to figure out some alignment. So, I think that's the art of civil legal aid eviction defense, is helping tenants and their advocates de-escalate the issue, lean into the conflict, and come up with some type of a resolve. And we found that the reasonable accommodation modification tool is a huge tool, one, to keeping people housed and making their housing more enjoyable. It's a difficult conversation. I think if trusted parties can have the difficult conversation with their clients, then there's processing, there's some dignity, there's some autonomy in that, and they can be more prepared to deal with the landlord who may not be a safe person for them, or they may not see that person as an advocate or someone in their corner. Oftentimes we hear, this person is against me, this person doesn't like me. So we want to try to help repair the relationship. So not only is the issue resolved, the accommodation is obtained, but that going forward, the landlord and the tenant can work together without being re-triggered by a past issue. So that's another issue I think that sometimes comes up for people experiencing mental and behavioral crisis or challenges, is there's a conflation of like, this always happens, both on both parts. Landlord, they're always this way, or the landlord, so we find, or I have found, that if I can have the more difficult conversation and help people figure out like, what's your win in this? Okay, you're getting really distracted over here and you go on to this other tangent, and that kind of weakens your argument, right? Can you say that to people? Because those are the things I think sometimes people need to hear. And I'll invite Elizabeth and Casey to opine on that with me. But
sometimes, the client is the problem, and there isn't necessarily a solution because they are either actively choosing to engage in this behavior, or they don't care about the impact they're having on other people. Sometimes there's some entitlement to, I can do what I want. I mean, there are a million reasons why people do the things they do, and nobody's the villain in their own story. So like, to them, it makes sense. But sometimes it's a matter of having that reality check of, look, if you keep doing this, you're going to lose your housing. And sometimes it's a matter of, okay, we can do reasonable accommodation. But yeah, I would say it doesn't save everything, but it is a very handy tool to have.
I always think about that when I'm in court with a tenant, which is that every other single person in that system knows where they're going to be laying their weary head that night, except the tenant.
Yep.
And the risk reward outcome for them is so horribly rigged, because the risk is that they're not eventually going to have a place to live. And so sometimes being able to discuss that with a person in that position is enough to sort of help them understand how critically important it is that they not have that happen to them. And that can help.
We have a question. Is there a way to incentivize landlords to be safe and work with tenants, because landlords' only incentive is making money and not to provide safe and adequate housing? Ooh, that's a loaded question.
Yes, it is.
You're asking some people who are ready to get on their soapbox with this one. I think that, following the law is important. They could be opening themselves up to civil liability. There is also the possibility that if you report it to an agency or governmental organization, then there could be fines associated with that. It's hard because the onus is really on the tenant to enforce their rights. And it's tough because not only is that their responsibility under the law, but comparatively, they have so much less power. And it's very frustrating.
Right.
And if you figure out a magical way to make that happen, where they just all suddenly care less about money and more about people, then let me know.
Habitability is one of my big ones. And at least in this state, it starts with a letter from the tenant to the landlord that says, "Dear landlord, as I told you, my plumbing quit working, my electricity isn't working, I don't have any heat," whatever the problem is, but it's documented on paper in a letter that identifies the tenant and the unit and the date and how to reach that person. And then in this state, there are time limits for the landlord to remediate whatever the problem is. If it is something related to health and safety, it's 24 hours. And that includes things like water and hot water. And if it's a busted appliance, like a fridge or a stove or something, that's 3 days. Anything else is 10 days. But if at the end of that 10 days, the landlord is still saying, "Oh, I have to order the furnace from overseas or something," then the remedy here is the tenant can go find the building department in the jurisdiction where they live,
or code enforcement.
And get the building department and or code enforcement to come in and determine whether or not the thing the tenant is complaining about exists and is a risk to their health and safety. And if it is, there's a really nice financial remedy for tenants. It's 3 times the monthly rent, plus their entire deposit, plus their costs of being displaced or their moving costs in cash within 7 days of when the landlord gets this information from a government agency. And the reason why this is enforceable is because landlords have mortgages, and mortgages require insurance, and insurance companies really rule the world. So if you can get to somebody like that and say, "Hello, you owe my client $10,000 right now, let's get it done." And if they want to complain about it, it's going to cost them 10 times that much. Okay, fair enough. So there's very much a benefit to making sure that landlords provide clean, safe, habitable housing that is up to code. We've also had discussions about limiting the ability of a landlord to commence evictions when their property is not in compliance with whatever the local code says. And I think that's a really good step in the right direction.
Yeah. More places can pass that. That'd be awesome.
Yeah.
And just, I put in habitability because we're talking to folks that are all across the nation. I put in the family housing complaints. That's if you lived in like a HUD or project-based unit. And then a housing voucher if people are having habitability or discrimination issues, so that you can contact them and then they can connect you to your local resources. And I just want to uplift that, like, people have gotten organized and they fought really hard for renters protections. A lot of that work has been really championed by advocates such as yourselves. So if you are caring about an issue or you're seeing something happening in your community, I would just encourage you to share that with an elected official via an email or some kind of platform where you can engage, maybe getting involved with the state organizing on housing alliance type stuff. But those are really powerful ways to help us improve renters' rights for everyone. We spend all day in our community saying, "You have that right, you don't have that right, you could have that right." So just a push for that type of advocacy, as well as sharing your advocacy stories with elected officials, is really powerful, because you actually have another layer of experience, right? Not first person, but it's definitely secondary trauma, and it may be informed by a first person experience as well.
What other questions do we have? Not seeing any pending.
No, I actually thank you so much. I don't know if we've had such a fast and furious list of questions and answers. I mean, this seems
Well, glad we got
remarkable
the
that
answers
there's
out.
like 25 questions and multiple answers in all of them. You all were fantastic. That was amazing. And I wish we could, the problem is I know the minute we summarize all this information, something will change. And so that's why it's really hard. We'll have to have you all back. I guess, I wanted to ask, if I could, and I'm sorry if you covered this, I was listening intently, I promise. When people are, so we're talking a lot about when it's reached this crisis level, something bad has already happened, discrimination has happened, some sort of action has happened. And, I know you touched on this a tiny bit, but I guess I'm wondering, for folks working out here with people who are living with behavioral health challenges and trying to, get along and do their thing and be responsible and all of that. But something is coming up, and it could be they're aware, and sometimes not. Maybe we're seeing that as that outreach worker, community-based case manager or what have you, or housing kind of support staff. But we're noticing, or they're noticing, that something is becoming a challenge now, and it's clear in their mind, or it's clear to us that it's related to a behavioral health issue. Before it gets big or formal, what would be a good strategy perhaps, and what, do we go to a landlord or talk to them and say, hey, and I know you said, yes, have a conversation, document it by email. I can understand there's risks in coming forth with that information. You're not required to do that. And conversely, if you're asked about things that don't have to do with your tenant's rights, that you are not obligated to share, protected health information about yourself or what have you. But I know it's come up in the past in my former jobs around people suddenly have a hospitalization they didn't anticipate, or they suddenly, had treatment came up and they didn't get to make all these arrangements with folks. So I guess I'm just wondering, like, at some point, are there ways to work with landlords prior to something bad happening from the landlord's perspective? Someone can't help if they're involuntarily detained. They go to jail and get caught up in this horrible competency, evaluation pipeline that's forever. And there are lawsuits about that, as you're well aware. So I guess I'm just wondering, like, at what point do behavioral health issues, really suggest we talk to the landlord? And that might be really scary for the person to talk about this. So Andra, I know you had your hand up, but it's a lot of complex question in there, but yeah, what are your thoughts there?
Well, I think just first and foremost, like, there are things that are happening in those one-on-ones with the client, right? And so, like, talking about renters, like, how's that impact your housing? Do you have any concerns about your housing? And getting folks you have a civil legal aid organization in every state. There is legal service foundation, corporation monies in every state. So there are someone can kind of help be a guide just to get some basic questions. And right now, we just don't have a luxury for renters in the United States to just rest on our laurels that someone else is going to save our housing, because that's just not true. And so, but what we can do is try to get people's questions answered early on, right? And then for the things that happen in an emergency moment, right? I think if they reach out to you and because you're the advocate they called while they're detained, or you were part of that process, then I think you can make a housing stability plan as part of that, right? Which is, we have a protective payee that can pay the rent, that we have somebody that could come and check on any emotional support or service animals or something of that nature. And then deciding, like, when do you have to disclose something? If something happened not on the property, it's none of the landlord's business. Okay. We've got a lot of looky-loos in 2023. And everybody need to look at their own paper and stop trying to read what's on somebody else's paper. And just because of that,
once people get to see or what they had an idea about what's on someone's paper, then they get to form what we call biases, implicit bias, based on just general facts. They could be true or false, somewhat supported, somewhat not. And then we take these leaps and bounds and we make all these inferences about what it is. And then that's how discrimination happens, that's how harm happens, that's how bad, unlawful evictions happen. And we know in our society, if you have a touch to the criminal justice system, whether it's an arrest that doesn't lead to conviction, or if it was a past conviction that just continues to haunt, we just know that that's a red flag for landlords. And so I guess what I would say is try not to be throwing that red flag too soon. And then I think it's just coming up with like what is the repair plan, right? This is it. Every person in the United States is going to have some type of a disability. At some point in their life, they will need a short-term or long-term disability. And we are finally in a space where we've made work more accessible for people with lived disabilities. We have different conversations. And so I think this is our chapter in human society to like really go bold for universal like access to housing for everyone. And I would say, as a case manager, if you can spot the issue, you can start to have the subtle conversation. And we all need a safe person to bounce our scary off of. Well, what if this happens? Well, I'm really worried about this. I'm embarrassed because of this situation that I'm in. I don't want my landlord to know, right? I'm aging and now I'm kind of moving into my silent years, but I don't know that I am quite that. So I might be just a little erratic, right? Like things just don't feel the same as they used to. And so then it's figuring out like what is needed. And if you think housing could be an issue, then it's come up with a housing plan. But yeah, there's a lot of times where I'm like, why did you tell the landlord you got arrested if it didn't happen on the property?
Yeah,
so that's what I'll leave you with. If you want them to know, then they're going to know, and they may not do what you need them to do with that information. So just,
I
That's
just
actually, oh, sorry. No, go, Elizabeth.
saw in the chat, somebody was suggesting that they were getting referrals from APS. Please send those to us. We can help. I mean, obviously, depending on what county it's in. I have had really good experience working with APS caseworkers when there's something going on that probably is more behavioral health than anything else, and it can get resolved. And so that comes back to an ADA accommodation through the courts. And then sometimes there's a guardianship that can be put in place. There's all kinds of things that the legal system can do if we know about it. And so if you as social workers are getting referrals from Adult Protective Services, send them to us. If you're going, what do I do with this? We can help. So, yeah.
And to build on what Andra was saying, yeah, I mean, it's a matter of making that plan. What is going on? What are you worried is going to happen? What are the client's goals? And what are your goals?
Right.
And what needs to happen? What little, because you can think big, but you also have to think little, because you can't get to big without taking a bunch of tiny steps. So what are the tiny steps to try to mitigate what's happening, to try to minimize the impact of whatever's going on with the client? Is there any way that you can start planning ahead on how you're going to handle this? And that's something that, you know, we're welcome to talk to, or pardon, y'all are welcome to call us, and we're happy to talk to folks. We have the King County Tenant Resource Line. I believe I put it in the chat a couple times, but I'll drop it one more time. And then we have a Q&A. And then, oh, it's gone. Never mind.
Yeah, I know we're nearly
we're
time, and it's really flown by. I can see all the people in the chat. I'll hand this over to Amy to take us out, but thank you so much for this information. I think it's always, you know, when I was out there doing this, you know, you think, well, on one hand, at least a landlord would know if there is a community advocate, with the tenant, sort of keeping eyes and ears and being, a resource. I think that's always the balancing thing, right? Is we want to be a resource for the client. We want to be almost a translator between, these systems that may not be clear to everybody, and also respecting the privacy of the person we're serving. So they're going to see us come and go, probably, as you said, looky-loos. But, so we often want to see how the apartment's looking as a case manager, but we also don't need to, share what isn't necessary or give, a landlord information that somehow is going to be used against them. But my experience is they're often really excited that we're around, we're trying to help. But, I know it's not always that way with every situation, but yeah. So thank you for all of your information, and appreciate you digging into an enormous amount of material. Maybe I'll let you type one more answer, but Amy, if you want to do our farewell slides, and but yeah, any last thoughts before we round the corner, Casey, Elizabeth, or Andra?
I'm answering a question right now in the chat, but thank you for having us, and thank you to all of you attendees. You have been lovely.
I think we're gonna have to make this a regular thing.
I mean, huge. I wouldn't mind.
Yeah.
I know there is so much information. So thank you all so much. I know I was busily writing things down as, I think about past events and clients in my life too. I thank you so much for hitting on, service animals versus emotional support animals. That's really big right now, at least, where I was working, especially during the pandemic. And I feel like, everybody's getting animals and lonely and needs support. So very much needed. I don't know if you guys know, I know we're wrapping up, but anything about laws and things with regards to who can write those letters. I know I was looking them up in the state of Washington, and really found that, and correct me if I'm wrong, please, but licensed clinical staff or psychiatrists could write the letters. But again, please correct me if I'm wrong. Oh, and Elizabeth, you're on mute.
Sorry. I think it's even a little bit broader than that.
Okay.
I don't think it has to be a doctor. I think you can open up medical provider and include people like ARNPs,
Right.
practitioners, stuff like that. And it can also be somebody who does therapeutic counseling. So as lawyers, we tend to not want to put ourselves in a position of being a witness. So I'm usually chasing down somebody else saying, you can do this, because you don't have to disclose anything except your opinion that there's a medical something going on and this person benefits from having this animal.
Right. And thank you so much for saying that too. In documentation, I know that we are often all, want to write things down, but really looking at HIPAA laws and what we shouldn't write down. I really appreciate it. And with that, I'm going to share my screen here really quickly. We do have a QR code again for our survey. It's very brief, and we really, sorry, just a second. Really would appreciate if people could fill out the survey. Getting my screen. There we go. And just want to thank you all so much for being here. This is so important. Obviously, you can tell with the amount of attendees that we had, all the questions. Thank you so much for your diligence in answering all those questions. And we will see everybody next time.